Global happenings today. We communicate. We analyze global news. Stay tuned.
Hello, good people. Welcome back to our channel. Though Wike's camp is rejoicing, considering the fact that the court, as the Supreme Court, has explained why they have reinstated Martin Amowole and the likes. But there are a lot of infractions which most legal luminaries have looked into, and if it is being taken up, it might end up indicting the likes of Martin Amowole. You're going to hear what this actually means, because it's actually an implication of a particular move they have taken. Now, they're looking at legal luminaries who have studied the case. They're looking at the impact and implication of the withdrawn affidavit on the River State case. Don't forget that at one point they came out openly to tell Nigerians that they swore an affidavit that they have stepped aside from PDP. In other words, they have defected from PDP. Long after that, they came out to tell Nigerians that they did not defect. And I can still remember, Sarah Reporter was the first paper of the media that carried it, that they have withdrawn the affidavit from the court. Now, the big question is, what is the implication of withdrawn affidavit on the River State case? And number one is that self-contradiction in court record. Said by withdrawing an affidavit they previously swore to, the lawmakers have created a serious inconsistency in the court record. This undermines their credibility before the court, violating the principle of approbation and reprobation established in Bàttle versus Perjury 1991. The second implication is that removal of legal basis for court orders. According to the article, this affidavit was the basis upon which they got court orders that kept them in office. By withdrawing it, they have potentially invalidated the very foundation of Justice Okorowo's December 15, 2023 order invoking the doctrine articulated in Bàttle versus INEC 2015, that an order based on misrepresentation become void. The third implication is that omission by omission. The strategic withdrawal of paragraphs specifically confirming the defection to APC constitute an implied admission under Section 20 of the Evidence Act 2011, comparable to the principle in Onibudo versus Akibu 1987. Potential legal consequences of this. It said, perjury exposure. Despite withdrawing the affidavit under Section 117, 118 of the Criminal Code and the principle established in FRN versus Ibori 2014, the lawmakers remain exposed to potential perjury charges for the previous sworn statement. Grounds for reversal say that this gives Governor Fubara legal team powerful grounds under Order 43 Rule 1 of the Federal High Court Civil Procedure Rule 219 to apply for, number one, vacation of Justice Okorowo's order, dismissal for abuse of court process, Pe Saraki versus FR in 2016, declaration that the seats are vacant under Section 109 subsection 1G of the Constitution. That effect on, what is the effect of it on Supreme Court decision? Said this revelation directly contradicts the Supreme Court's finding, providing grounds for review under Order 8 Rule 16 of the Supreme Court rules, similar to INEC versus Obi in 2017. Procedural implication say that discovery process under Order 43 Rule 3 of the Federal High Court, Governor Fubara's team can depose the court registrar to confirm the withdrawal, establishing new evidence, fresh legal strategy. This development enables legal remedies, including motion to dissolve injunction under Order 26 Rule 11 of the Federal High Court rules, application for strikeout pay, Bàttle versus State 2002, request for expedited hearings citing Dingi Yedi versus INEC 2010, judicial notice under Section 122 of the Evidence Act 2011. Court must take judicial notice of these procedural irregularities, significantly weakening the lawmakers' position. Now, what's the political implication? Number one, public perception. The secretive withdrawal create appearance issue addressed in Alero versus INEC 2012, where the Supreme Court emphasized transparency in election-related proceedings. Strategic contradiction. These contradict their public position, invoking the doctrine of extopel per rem judicatum, established in Bello versus AG River State 2016. The withdrawal of the critical affidavit fundamentally alters the evidential landscape, providing Governor Fubara with powerful new evidence under Section 83 of the Evidence Act 2011 that the lawmakers themselves acknowledged their defection in court, then attempted to withdraw that acknowledgement when it became legally disadvantageous. That was the position they gave. I don't know how this will go an extra mile in helping Fubara, because already they are not going slow on him. I think today they will be embarking on a 12-week recess, and there are a lot of demands that they have put forward to him. One of it was that he has to sack everybody that are currently working with him and present a new list, which most people have faulted it that they are not in position to tell the governor to provide list of commissioner or commissioner nominees, because it is the exclusive right of the governor to work with or without commissioners. It is enshrined in the Constitution. So that is strictly his own jurisdiction. The only thing is that if he appoints them, he needs to send the names across to the House of Assembly for them to screen it and also confirm them. So right now the position of Fubara seems to be quite advantageous. I don't know how his legal luminaries will kind of stand on this to create a new legal move that will help to kind of invalidate a lot of things and possibly call for review of the position of the Supreme Court. My colleague is in the house. What's the standpoint on all of this? Do you think that anything can come out from this, considering the position of the Supreme Court in respect to these defected lawmakers? Now, everything borders on the fact that, they defected, and after defecting, they went and got an affidavit, which was the grounds with which the first case, Okorowo's case, stood, that, they brought an affidavit that nobody should take over their position and all of that. That affidavit has been withdrawn. So for them, that's perjury. And they went out also in the public and they denied that they never defected. So that can kickstart an advantageous legal battle for Fubara. Do you think that all of this can work out, considering the judicial system we find ourselves?
A lot of complexities, but the challenge now is it's not left for judiciary to stand tall and stand with integrity. Just fairly recently, we saw what happened with Natasha's case in the legislative arm, and the Nigerians are still battling with that. Now, with this, there's no way, no matter how they want to, because the pro-Wike camp kept on saying it to all Nigerians' faces that there's no need for any more cases, that the issue of their defection have been tackled. What about the case of perjury? Are we going to, because the essence of Constitution, which should stand tall always, is to ensure order, law and order, regardless of whose ox is being called.
Exactly.
But in a situation where we begin to interpret the Constitution to suit us only when it is in favor, and when it's not in favor, you begin to twist it. I'm afraid what we are calling for may not be too nice, but I feel that it is now in the hands of Judicial really to get this right. Perjury is what we are looking at here.
Yeah.
And the question now is, will judicial rights? It's not something that was hidden. It's on the social media. The evidences are everywhere. So we can't be looking for evidences. Nigerians have them all in their smartphones. And the Supreme Court, in all honesty, can say they've not been seeing it on social media. But then again, that this is the law. Let's say it plays out, if you ask me.
All right, let's leave it there. Let's make a conversation on. Do you think this can pull through in the law court and will put Fubara at an advantage?